For Creamer Media's Polity, I'm Sane Dhlamini. Researcher and analyst Professor Raymond Suttner joins me to discuss the courts and politics. Welcome, Professor.
Good morning.
A lot of your article is historical, and you relate that history to a failure to appreciate the different status of the Constitution and the courts today. How relevant is that, in fact?
Yeah, you know, obviously some people are criticizing the courts purely because the courts are enforcing the law and they want to break the law. But I think there is something else there which relates to the history of the judiciary and the status of the Constitution that is very different today from that of apartheid. Now, it's not just that you have had apartheid laws then and that those are not allowed. It is something that this thing of the Constitution being supreme is not something which applied to South Africa, but it's also something that didn't apply to Britain. Not just because Britain doesn't have a written constitution, but Parliament was supreme. Any law by Parliament could not be set aside by a court of law unless for some reason it did not follow the procedures for passing a law. You know, it didn't go through both houses of Parliament, and the Governor-General, the President, didn't sign it. Now, what is the situation today, which is very different, and it's not the same as the United States. In some ways, the United States of America has always had a Supreme Court that was under the Constitution and was capable of making decisions which set aside some acts of government or legislation. For example, at one stage, the Supreme Court had decided that to have separate facilities could be equal. But in 1954, if I'm not mistaken, the Supreme Court of the United States made a different decision, setting that aside, saying separate facilities are inherently unequal. Now, in some ways, that model is the model that we have today, although in making the Constitution, they did draw more on the Constitution of Germany than that of the United States. But where it is very much more different today is that the Constitution is not just a procedural protection. For example, under apartheid, they could arrest you without trial, not allow you access to your lawyers, or restrict you, take away your passport, all of these things. And it was very hard for your lawyers to find a way of breaking through this legal framework that suppressed the rights of human beings. They could only do so if they could show that the minister or the official concerned had not applied his or her mind to the matter. Now, that didn't mean that they could say objectively, here are these things, he or she could not possibly have intended this. As you had to be able to show that for some reason the minister had made a decision subjectively, which was not really a decision. He or she had not, if you could prove that in order to make this decision, he ought to have known the name of the person. And if by mistake they put the wrong name, well then obviously he or she did not apply their mind. So it was very, very narrow. Now in the present situation, you have a much wider range of conditions under which the courts can intervene. For example, when the courts deal with social and economic matters, they are not going into something purely because they are compassionate. The Constitution itself in the Bill of Rights says that people must live with dignity. It says that basic needs must be met. So if someone's dignity is impaired, or if they are thrown into the cold of winter with no accommodation, the court, you can approach the courts, and the courts actually have a right to intervene, as they have done in the Grootboom case and over various health-related and other issues, in order to protect the rights of individuals, human beings. Now, in some cases in the apartheid era, some courts did their best to protect individuals, some judges, but they didn't have the same scope. The same goes for the question of discretion. There is a wider basis on which the appointment of Dhlamini as head of the NPA was set aside. There is a wider grounds on which the appointment of Dhlamini was set aside. What they did, they didn't have to purely rely on the state of mind being one of no decision being made. What they could do is point to data that the Ginwala Commission had shown that Menzies Dhlamini had not acted with the integrity that the member of the legal profession should have acted with. So they could say, that being the case, acting in good faith, the minister could not possibly have rationally appointed him to the post, therefore they set it aside. In the case of Dhlamini also, they had the findings of another judge that he was a liar, that he misled the court, all of these things, and that finding had not been appealed against, not been set aside. Consequently, they said that if you appointed someone with this finding, it was not rational. In the same way, they're being asked to set aside the cabinet reshuffle as being inherently irrational by virtue of a range of factors. My belief is that that one will be much more difficult to show. If they're relying on the intelligence report, is that the only thing that the president relied on? But nevertheless, the principle that you cannot simply, as the person with the power to appoint is no longer applicable. There are a number of bases on which you can change things, and that is different from South Africa and the UK. Now, the UK obviously has got a much better human rights record, hasn't got a written constitution. There are a lot of protections there, but it doesn't go as far as our constitution in terms of social and economic rights.
So is there no danger of our courts being perceived as siding with the opposition against the government? And also, why do you caution the opposition about overuse of the courts?
You see, I think the courts are very cautious with these cases. They don't easily, you can see this early on when Judge Davis said that they must order a motion of no confidence in the Western Cape High Court about 3-4 years ago. It was very, very limited. He only made the judgment so far as was necessary for the particular case. Likewise, in entering into all of these cases, the court only makes a decision going as far as is necessary to give relief. Now, in the case of the secret ballot, my belief, if I were to venture a guess, is that they're not going to order the Speaker to have a secret ballot. They will probably find that the Parliament, the Speaker has the right to allow a secret ballot if Parliament wants it. But they will not say that Parliament must have a secret ballot, because that is a decision, I would guess, that they would find that Parliament ought to take itself, and they would not like to be seen as the court to be going into territory that properly belongs to the legislature. With regard to the second part of your question, I wanted to say that the opposition and organs of civil society like Freedom Under Law, Helen Suzman Foundation, Corruption Watch, a number of others have made very important gains through the court cases that they've brought. Now, in the case of Freedom Under Law, Corruption Watch, and to some extent Helen Suzman Foundation, you can say that legality is their core business, so that they should be doing these cases. In the case of political parties, I'm not saying they shouldn't be bringing cases, but what I'm saying is they need to be clear that a victory that they achieve through the power of someone else, that is a court, is not an indication of their own political power, because they will still have to win power on the ground. And if you spend a lot of your resources in channeling it towards winning court cases, you have to be very aware of the fact that, those are resources that are taken away from activities in building organization, building branches, in preparing for various campaigns and elections. And I think there is a danger, especially with the DA, which goes to court a lot, although I'm not saying that any of these court cases were unnecessary, but if I were them, I would be very cautious. Just as an outside observer, I was watching what was going on in Nelson Mandela Bay, and I thought, if they try and kick this chap out, they're going to sink it. So I'm just watching as a person who's not DA, but I'm saying, if all there is, or not all, if a significant number of resources are directed there, and you have successes, you may get into the habit of outsourcing opposition, in a sense, to the courts, who don't want to be in that position themselves.
Thank you, Professor. That was Professor Raymond Suttner speaking to Creamer Media's Polity about courts and politics.